Hi, I'm Kate Tompkins. I'm a specialist children and family barrister at 36 Family. I also sit as a recorder in the family court and am a specialist children's mediator.
Hello, I'm Will Tyler. I am a children law silk. I'm head of chambers at the 36 Group. I also sit as a deputy High Court judge and as a recorder in the family court. I'm a qualified arbitrator and I hear early neutral evaluations. This is going to be a short webinar to consider the use of arbitration and ENE, early neutral evaluation, in private law children cases. The context, of course, is that this webinar takes place in the midst of the COVID-19 outbreak, with the self-isolation and the closure of courts that's brought to us all. Even with the edict from on high to get on with cases, wherever possible by virtual means, I imagine all of you would have experienced, as we have, case after case being adjourned out of the court lists, which brings two issues firmly to the fore. Number one, what about getting on with cases via alternative non-court dispute resolution? And number two, if so, how to engage in that via remote virtual means. We're going to focus in this webinar on two particular forms of dispute resolution: arbitration and early neutral evaluation. Before we come on to the detail of those, a crucial question given the context, and this is one of the questions we've received from several people in advance, is this, and I read one of the questions: I'd like to know about directions you need if you want to go off to ADR in the middle of proceedings, and how you can persuade the reluctant to attend. So Kate, if the case is already up and running in some guise, can it go off to ADR?
Yes, in short, there is nothing stopping any party going off to ADR in the middle of proceedings, not just to mediation, which is probably the most common form of ADR that we see proceedings being paused for parties to participate in, but to any form of ADR, including early neutral evaluation and arbitration. The second question that comes from the question that you asked is, what directions from the court would you need if that was something that the parties wish to do? Firstly, a direction to adjourn the proceedings themselves, a direction dealing with when and how the parties must then inform the court if the early neutral evaluation has been fully or partially successful. And that's effectively the court being told jointly by the parties what issues have been agreed and what issues, if any, remain for the court to then go on to determine. And then, of course, a direction listing the matter for consideration of any issues that require determination following the early neutral evaluation, whether that listing be for a directions hearing as to work out how to go forward, or whether that be immediately for a final hearing, depending on how far you've already got in the proceedings themselves. The directions required, as I've just set out kind of informally, are set out in Rule 3.4 of the Family Procedure Rules more formally. The other question that arises is, how will you persuade the reluctant to attend early neutral evaluation? Well, if one party's reluctant, then you of course set out the advantages of the process of early neutral evaluation to them. But in the current climate, you may in fact find that both parties are not willing to attend and are reluctant, and may need to be persuaded or not. Many courts, as Will referred to at the beginning of this webinar, are simply adjourning private law cases currently without any notice to the parties that that is what the court is considering, and without any consultation with them as to whether or not that would be an appropriate course of action for that particular case. Mr. Justice MacDonald, in more guidance that has come out today, version 3 of the remote access family court guidance, flags the pressing need currently for all of us to be reducing pressure on the judicial resources and to be exploring with parties whether ADR in any form is merited. Family Procedure Rule 3.4 subsection 6 allows the court to adjourn for consideration of ADR methods of its own initiative. But I think what's important to know is that if the court does this of its own initiative, which we are seeing it do frequently, certainly in a lot of my cases over the last 2 weeks, it must do so in accordance with Rule 4.3, subsections 2 to subsection 6 of the Family Proceedings Rules. Those rules provide that if the court is considering adjourning for the parties to consider and or participate in a form of ADR, that they must allow parties the opportunity to be heard on that issue. If the parties being heard means that the court is going to convene a hearing to listen to any positions put forward, then the court must give 5 days' notice of any such hearing. If the court isn't holding a hearing to consider views and an order is just made, it's important to know under those family proceeding rules that if you want to vary or set aside the order, you have 7 days of the date that the order was served on the party seeking to vary or set aside it to make those representations to the court. So if it does happen to you and you are not happy with it and you remain reluctant to attend, then it's 7 days from the point that the order was served on you to make your representations to the court for the court to deal with your case in a different way.
I don't know about you, Kate. When the rules came in, a huge deal was made about the court's ability to push parties out to alternative dispute resolution. I can't think of the last time in private law proceedings when a judge of their own motion said, come on guys, what are you doing? Go off to mediation or arbitration or E&E or whatever it is. Do you have different experience?
I have a different experience. I think I have had one case within the last 12 months where the court has said this really is suitable for mediation, asked both parties at court, effectively persuaded them to agree to going off for mediation and adjourned the matter for 3 months to see if mediation would work. But because we now have the requirement to go through mediation in advance of issuing most private law proceedings, in most cases it's happened where it's suitable for it to have happened and it just hasn't worked. So adjourning off again mid-proceedings for mediation is quite a rarity.
What ought to be happening in the COVID-19 climate is rather than simply administratively booting cases out for X weeks or months, the judges should list them immediately for very short directions hearings at which that question is asked in accordance with the rules. Is this suitable? And then pressure can be brought to bear on the parties, if it's the right case, to go off to ADR, to virtual ADR, and their case can be done and sorted before even the courts are back up and running again.
Absolutely. And it's about also not just ADR, but the parties agreeing the right type of ADR for their particular case and for their particular personalities, whether that's mediation, whether that's early neutral evaluation, whether that's arbitration.
Yeah. Well, perhaps it's useful at this stage then just to recap on the key features of the two forms of dispute resolution that we're talking about today, looking at the pros and cons, depending on the type of case in dispute. So arbitration, first of all. You will all know this, the big difference about arbitration as compared to other forms of non-court dispute resolution is that the parties agree in advance to be bound by the result. The result is known in children cases as the determination rather than the judgment. But at the point you sign up and go to arbitration, you know that you will end up with a final result to your case. So in that sense, it's just like any other conventional court hearing. In other senses, it's not. For example, parties can choose their own arbitrator. They can choose what level of expertise, what manner, what seniority, what cost would fit the particular case. There's a very wide panel of qualified arbitrators, ranging from retired circuit and high court judges through practicing QCs and other senior juniors, many of whom sit as deputy high court judges or recorders, through less senior practitioners. There are solicitors. There are those with a strong mediation background. The parties, if they want to, can choose whomever they want to hear their case. That choice then gets taken through to other parts of the arbitration process. The arbitration can take place wherever, whenever the parties choose, just as long as the arbitrator is able to accommodate it. So unlike HMCTS, the arbitration won't be adjourned due to an urgent care case coming into DJ X's list, or because DJ Y had a case the day before which overran. The case will go ahead. And the other single advantage is that arbitrations can be arranged at very, very, very short notice. So there are loads of examples, both recently, very recently, and in the last 12 to 18 months, of arbitrations being arranged at 2 or 3 days' notice, often after a court hearing is adjourned by the court. The parties are bound by the brief deemed costs, and rather than lose everything, an arbitrator's found, and lo and behold, within a very short amount of time, the case can be heard to conclusion. So those are the principal advantages of arbitration: speed, flexibility, choice, and perhaps counterintuitively, costs are often reduced, because even though you pay for the arbitrator, a function of the greater speed, the expertise of the arbitrator, the fact that you're not sharing your court day with 5 or 6 other short cases, often means that at the end of the day, the costs are significantly lower than they would have been. Disadvantages, hard to think of any as such. A general rule, of course, is that an arbitration determination can't be appealed. In fact, of course, there are very few successful appeals in private family law anyway, but we have to think about that factor when deciding if a case is the right case for arbitration, or perhaps more often if a client is the right client for arbitration. Also worth noting, an arbitrator doesn't have all the powers of the judge, for example, to make a Section 37 direction, to bring a local authority on board, or to commit a party to prison, that sort of thing. Rather, the arbitrator makes the decision, which is then reduced to a consent order and submitted to court as a consent order for effectively administrative confirmation. The cases then particularly suited to arbitration are classically those where the parties just need a decision, as opposed to those cases which will rumble on forever and ever in the family court. So where there's a dispute about schooling or education, about routine non-life-threatening medical treatment, straightforward child arrangements or variation of pre-existing child arrangement orders, they're cases when the parties just need to know what the judge or arbitrator thinks so they can get on with their lives after the hearing. Exciting news, previously cases with an international dimension were out of scope for family children arbitration. IFLA, the Institute of Family Arbitrators, excluded them from the scheme when it first launched. It is said that it's about to bring into scope international relocation cases, as long as the relocating country is a party to the 1980 or the 1996 Hague Conventions, or the Brussels II revised regulation. Again, those are cases where very often both parents have a reasonable point of view, but they can't agree, and there's a signal difference between England and Australia. There's nothing in between. The parties need a sensible, reasoned decision, and that is as easily but much more quickly achieved in arbitration than in the court process. On the other side, it's generally thought that those cases with a significant welfare issue, with serious allegations to be tried, for obvious reasons perhaps, aren't appropriate for arbitration. Kate, what about early neutral evaluation? Which cases classically fall within that, and how does E&E differ from either arbitration or mediation?
Okay, so E&E is a form of alternative dispute resolution in which a neutral qualified third party provides the parties in the dispute with a non-binding assessment of the disputes between the parties. It's very much not an adjudication, but only an evaluation. The sorts of people who provide early neutral evaluations span from either very experienced barristers, but some of whom also sit as judges, or experienced solicitors, some of whom also sit as judges. So you go to a professional who is experienced in your field, in whom you would have confidence, would be able to fairly and expertly evaluate the issues that are in dispute in your case. The aim of early neutral evaluation is to focus attention of the parties on the really relevant issues in dispute between them, to allow each party to appraise their case realistically, effectively. It's a third-party expert reality check for both parties in respect of the arguments they are putting forward and the positions they are contending for. The neutral evaluation itself is then taken by the parties as a basis to enter into discussion with one another thereafter in respect of the disputed issues, with the hope that will significantly aid agreement and settlement of those disputes. The advantages of it are that it can be arranged and undertaken in a very short space of time. It is cheap compared to the other alternative dispute resolution methods, and often quite quicker. So it can be facilitated on limited resources. It can be very flexible in terms of when it happens, how it happens. And it forces, I think as I've said earlier, each party to really consider the respective strengths and weaknesses of their cases, of their positions, with a view to highlighting the benefit of those issues themselves, and more importantly, the benefit to their children of then resolving their disputes. And it's
the clue may have been in the first initial early. And that's perhaps why it's cheaper. What stage classically then would a case go to E&E? It's before, is it the bulk of the evidence is set out and reduced to writing, before experts are commissioned, before the parties become entrenched in their positions?
Well, I think when you say what's typical, early neutral evaluation is used in financial proceedings, historically much more commonly than in children proceedings. Very rarely used in children proceedings, though I can't see why, and I think probably in the current climate it is going to be used more. In respect of the ideal time, the thing about early neutral evaluations is that they can assist parties at any point that parties feel that type of assistance would best progress their case forward. For some cases, very much, that is going to be pre-proceedings. For some cases, that is going to be when they get stuck, potentially at a point once proceedings have been issued. It also depends on the issues within the proceedings themselves and the disputes that need to be determined. If they're the type of issues and disputes that require the input, for example, of a Section 7 report, whether that be by a CAFCAS officer or an independent social worker, then obviously that cannot happen until those reports have been obtained within the proceedings. So it depends on the issues and depends on when it's going to best assist the parties in reaching an agreement. Does that answer your question?
Yes, no, thank you, that's very helpful.
In terms of the disadvantages, well, the main disadvantage is if it doesn't work and you have adjourned your proceedings for it, it has then delayed a determination being made by the court on the issues. It has costed the parties more money, and it has cost them the emotional resources to engage in such a form of alternative dispute resolution. It may cause parties to take a more entrenched position if one comes out of the evaluation feeling very much that they won it, the other feeling very much that they lost it. It may then mean that settlement is harder to reach if somebody becomes more entrenched because they have been given greater confidence in respect of their position. And quite often it's not suited to multi-issue or complex cases. Early neutral evaluation is a far less nuanced form of alternative dispute resolution. It's effectively just a straightforward sift and evaluation of the evidence. So where there are more issues or where there are more complicated issues, it may not fit easily those sorts of cases. That leads me on to the sorts of cases that are well suited to early neutral evaluation. Relatively straightforward cases with very limited significant factual disputes. Although having said that, there would be nothing to stop the parties, if they wished to, asking the evaluator to evaluate effectively on an either-or basis. So if this factual dispute was proved in the favour of the mother, what would the evaluation be? If it was not proved, what would the evaluation be in those circumstances? That's possible. I haven't seen it done, but there's no reason why it couldn't be. It's also best suited to those cases where there's no real welfare concerns, or those cases where there are some welfare concerns, but they have been addressed by the time the parties go to early neutral evaluation, either by some involvement from children's services in the form of a child and family assessment or some other form of initial assessment, or have been dealt with within proceedings by a Section 7 report from an independent social worker or a CAFCAS officer. In respect of proceedings where there are safeguarding issues, it's unlikely to be suited to early neutral evaluation. Again, nothing stopping an early neutral evaluation, but it becomes much more difficult to see how the party with the safeguarding issues would be able to accept that if they are denied by the other party. One of the questions that was received in advance of this webinar was what needs to be done in advance to get an arbitration or an early neutral evaluation up and running when you have persuaded one or both reluctant parties to do so. In respect of early neutral evaluation, there needs to be, I think, a clear agreement between the parties before the early neutral evaluation process is commenced. That agreement should be in writing. The best way to think of it is it's akin to a mediation agreement that you would be entering into. So you would see the same sorts of things set out in an early neutral evaluation agreement. So the sorts of things that would be in there: agreement as to the scope of the dispute or disputes that are to be determined by the evaluator, what material should go before the evaluator. Quite often, if you're in court proceedings, that's more straightforward. It may well be simply the court bundle as it is to date, with a summary of positions from each party in respect to the issues that the evaluator is being asked to determine. In respect of cases that are pre-proceedings, it may be more difficult, and it may be wise for the parties to consider setting out effectively in a statement form the background to the case and their positions on each of the issues and why. how the evaluation is to be conducted. Early and neutral evaluations can be conducted anywhere between it feeling like a formal court hearing or a very informal therapeutic mediation session. So you need to agree with the other party or parties in advance how the evaluation is going to be conducted and what level of formality is required. The manner in which the evaluation is to be delivered is important to agree. Should that be in writing or should it be orally? Perhaps more importantly, should be agreed whether you are asking your evaluator to give an evaluation in full or in summary form, and whether or not you are asking the evaluator to specifically indicate which of precise differing proposals he or she prefers. So whether it's alternative weekends or 1 weekend a month, for example, or whether you are just asking your evaluator to provide comments on the advantages and disadvantages as they see it of each party's position. There's advantages and disadvantages to both approaches. The key disadvantage to asking your evaluator to give a very specific view on issues in dispute is that it may mean that the party who has contended for something different, it's very difficult then to settle because there's little room to compromise, because a party who's perceived that they have won is not going to agree or consider any other alternative. So that needs to be thought about. Obviously, who's to pay for it? Who's going to pay for the costs of the process? How and when? And whether the process is going to be without prejudice and is going to be confidential, and in what sorts of situations it would be envisaged that the prejudice might be waived and the confidentiality. Well, in respect of arbitration, there's probably some common points, but specifically in respect of arbitration.
Yep, so an arbitration, or setting it up, is a slightly more formal process, although it can still happen really very quickly. IFLA has a form catchily called the ARB1CS, in which the parties have to fill out the basic information, names, details, crucially, of course, the issue in dispute, and the signed agreement of the parties to be bound by the arbitration. On the form, the parties can choose their own arbitrator from the panel. They can ask IFLA to choose from a shortlist which they propose, or they can ask IFLA to choose anyone from the whole panel. There's also a safeguarding questionnaire, and the most important fact I would want those listening to this to take on board is that before IFLA can accept an arbitration and pass it to the arbitrator, the parties must have either a CAFCAS report or a CAFCAS Schedule 2 letter in current proceedings, or if not, the equivalent of the CAFCAS safeguarding letter is a basic disclosure certificate from Disclosure Scotland. That's right, it's Disclosure Scotland, even if it's an English case, because the English Disclosure and Barring Service won't issue to individuals, only prospective employers, but Disclosure Scotland, which has access to exactly the same databases, will do. That takes about a week or 10 days when everything's working well. There seems to be some temporary disruption at the moment, born no doubt of the COVID-19 crisis. But the best advice I can give is this: if you have a case, whether it's currently in court or not, which may need a final hearing this side of Christmas realistically, and which may be suitable for arbitration, make sure you have either a CAFCAS letter or get the Scottish Basic Disclosure Certificate. It may be the best £25 your client ever spends if it means he or she gets their case sorted out months more quickly, and because of that, far, far, far more cheaply. Moving on then, another question on the minds of many is how effectively to deal with non-court dispute resolution hearings remotely. Common to both early neutral and evaluation and arbitration are certain ground rules for which legal representatives should prepare their clients. These ground rules are likely to be agreed in advance and may well be read out in advance at the beginning of the evaluation or the arbitration. They would include principally reminders that the parties, if attending remotely, need to ensure a private space for the duration of the hearing or session. And private most certainly means not a space in the earshot of the child in dispute who's old enough to know what's being talked about. Reminders to check that everyone realises what the other rules are, confidentiality, without prejudice, whatever's been agreed. A reminder that the parties agree not to record the evaluation or the arbitration themselves if that's what has been signed up to. Not to be live feeding to anyone else, perish the thought. And something we're all learning now, basic remote hearing etiquette. For example, muting your mic when you're not speaking to avoid the cat or the keyboard or the next door neighbour's lawnmower from disrupting proceedings. If you want to be heard, indicate visually. More specifically then in relation to arbitration, many think that remote hearings are ideally suited to this form of dispute resolution. You will have an expert, professional arbitrator who will have read the papers beforehand. You will be likely to have relatively few witnesses. Often it's only the parents, perhaps an ISW in place of a CAFCAS officer. And that sort of hearing, then with submissions either from a lay party or from lawyers, can take place just as all of the virtual hearings in court we're already becoming used to take place. The difference may be that with platforms like Zoom, there's a functionality not always available to the court. For example, you can easily include confidential virtual breakout rooms. There's a facility to record automatically. And if you choose the right arbitrator, they're likely to have access to the full suite of digital resources and again, dare I draw a comparison with the judiciary, know how to use them. It could be a little bit more hit and miss as we are learning at the moment. So arbitration, most of us think, can, in almost every case, very easily be suited to remote means. With Zoom, you even have access to separate interpreter rooms if you have parties who need interpreters, and it's very easy to make other allowance for particular special needs of any party or witness. Kate, arbitration is perhaps more straightforward because it tends to follow more closely the pattern of court proceedings to which we're all used, even if it's more informal. How might a remote early neutral evaluation look?
I think the answer is however the parties want it to look. It's either going to be on papers or it's going to be face-to-face by way of video or audio link at the current time. If it's on papers, the evaluation will simply be delivered in written format, circulated by an email. If there are any questions that the evaluator has when determining the issue on papers, those questions can be communicated and then responded to via email without any difficulty. If it's face-to-face, and in the current climate, face-to-face by using a platform such as Zoom or Skype for Business or by telephone, again, similar to any remote hearing, at the moment, the ground rules need to be agreed in advance. It's often also quite useful to agree a backup method of communication if the method that you have been intending on using breaks down for any reason, simply so you don't lose the impetus and the opportunity to have the evaluation if that's the case. In terms of them being conducted, anyone can be there who wants to be there and who the parties agree to be there, and that can be any combination of the parties themselves and their legal representatives, and the attendance is simply to answer any questions that the evaluator may have, and for the evaluator to deliver the evaluation. The same rules apply if the evaluation is going to be undertaken remotely through one of those forms, and it's going to be heard. There should be no recording, there should be no live feed of the evaluation, and of course the most important thing that you've already stated in cases where children are concerned is that the participants and the legal representatives all need to confirm that nobody else is present who can hear the evaluation process, and in particular the parties to confirm that the child or any other children in the household are not able to see or hear the evaluation itself. But it's very, very flexible. So in short, however you want it to look, it can look.
So in the last part of this webinar, let's just look at those few questions that we were sent, which we haven't dealt with in the body of what we've talked about. One of them was this, Kate: what disqualifies an early neutral evaluation? For example, would domestic violence make it unsuitable, as, for example, may occur in mediation?
Again, the answer is maybe. It depends what the domestic violence is, the context and the degree of it, and it depends what the issues are that are requiring determination. For example, if there has been domestic violence historically, but there has already been a determination that there should be direct face-to-face contact between the perpetrator and the subject child, and the issues are timings of handovers or location of handovers or what indirect contact should look like, then there would be no reason why that wouldn't be suitable for early neutral evaluation. But you can equally see other cases where the degree and context of the domestic violence may be very different, and the issues in dispute may mean that it's definitely not suitable for early neutral evaluation. But as with mediation, those sorts of cases should be relatively clear as not being suitable when you see them.
Presumably, as with any form of dispute resolution, even though the procedure rules don't strictly apply, we'll all look to PD 12J to see whether there are unresolved issues of fact in relation to domestic abuse as alleged, which, if found as fact, would make a difference. And if so, it's probably not suitable to proceed to any conclusion without a tribunal making a determination on those facts.
Yes, but that's also important to bring it back to what it is that you are asking the evaluator to determine. Are you asking them to determine, in accordance, for example, with Practice Direction 12J, whether they could give any evaluation, or whether that evaluation would be impacted upon by virtue of disputed facts being determined one way or another?
Yes, well, we've received a number of questions in a similar vein aimed at arbitration. How is arbitration appropriate if there's a genuine welfare concern? Is it appropriate to use a mechanism that really means a parent agrees to waive their right of appeal in decision-making where there are real welfare issues? If arbitration really is arbitration only really appropriate for cases with no welfare issues? So the same theme being dressed up in different ways. I think the answer is really this. Of course, arbitration is unlikely to be suitable for cases where there are really serious allegations, for example, domestic abuse, and for example, sexual or physical abuse towards the child. But with proper forethought from legal professionals, the right cases will select themselves. So those cases in which the parents or other parties, having had arbitration properly described to them, feel comfortable with the process, are likely to be those cases which are suitable to be arbitrated. My conclusion so far as arbitration is concerned is this. We're living in strange times, stranger than most of us have seen, and we have to think more creatively about how to give parties and parents the answers and the access to justice they need. But arbitration is not some newfangled process. In trade disputes, arbitration has existed since the very birth of commerce. For sure, it's newer to family law, and for sure, it's a bit newer even than that to children cases. But it's nothing to be frightened of, rather the opposite. If referral to arbitration allows parents and other family members to obtain justice from effectively a judge of their choosing, and while escaping our creaking, already creaking and now closed family courts, then for many people it's likely to be a pretty good option, and especially so if, as is the case, it can be conducted entirely virtually and very speedily.
In terms of early neutral evaluation, effectively I endorse everything that Will has said as to the benefits of arbitration. Also, in these current odd and difficult times, parents are going to need to find an alternative way in which their disputes in respect of their children are going to be determined. Most parents, and especially most children, can't await the sorts of timescales that appear now to be involved for private law children cases that were otherwise being heard in the magistrates' court or before district judges. They are simply being adjourned until a date in a future that for most parents and children will simply be too far away. The only other alternative is alternative dispute resolution. There are many forms. Not every form will be suitable for every case. Early neutral evaluation is a good fit for those cases where parties really want to try and bring about agreement and do it swiftly at the lowest cost possible. And it's suitable for those cases where the issues in dispute are actually very easily resolved if each party has a third party giving them a reality check in respect of what it is reasonable and appropriate and just for them to be seeking. So there is no reason why these alternative dispute resolution processes cannot be conducted remotely. Early neutral evaluation is also not new to family proceedings, though it's relatively new to children proceedings. It's been happening in financial proceedings for a very long time now, and it can be done, and we will be seeing more of it. Doing them remotely has their own challenges, and hopefully we've flagged up some of the pitfalls and the advantages to doing ADR remotely. We will all have to be careful. We will all have to be sure that things continue to be done professionally and with boundaries in place. But it is a way that parents moving forward in these times can have the issues in respect of their children resolved for them, unless we're all going to be waiting a very long time, it would seem, for that to happen. So, Will, unless there's anything else that you would like to add?
No, thank you. I think that's us done. I've been Will Tyler QC, privileged to be presenting with Kate Tompkins, with both members of 36 Family. You'll find our details, I hope, at the end of this webinar or on our website. Thank you for watching.
Thank you.